So we started this conversation a few weeks ago when we were looking at common myths surrounding retirement. And tonight we're going to give you some of the actual steps that you need to take to plan for retirement and what happens afterwards. I know my money makers are listening keenly to this particular conversation. You guys are taking notes. Take out your notes app, take out your pen and your paper, whatever it is that you prefer. But this is going to be one for the books, one that you definitely want to pay keen attention to. Joining us now to discuss is managing partner of Michelle Thomas and Associates, Michelle Thomas herself. Hi, Michelle. Welcome to Taking Stock.
Hi, good evening.
All right. Good evening. Don Webby. That's the name. Gosh, why did it take so long to come to me? RIP to Don Webby on behalf of Taking Stock and the crew. All right. So Michelle Thomas is joining us. She's the managing partner and founder of Michelle Thomas and Associates. Before we start, just tell us a bit about yourself. Introduce yourself to our viewers.
Well, I'm Michelle Thomas. I am an attorney at law now, 10 years at the bar. I do specialize in estate planning. I do a lot of real estate. I'm also a proud supporter of your show. And a little about me, I like to read, I like politics, and I love, reading about Jamaican and how we have evolved. So essentially, that is a little about myself.
How long have you been an attorney?
10 years this year. So I'm celebrating 10 years at the bar.
Well, congratulations. So, what brings you into this area of attorneyhood, retirement planning, of legal planning and legal expertise?
At first, I must say I do have a mixed practice, but my love, I realized over the past 5 years has been estate planning and real estate. And it's because I realize oftentimes when you have someone die and the will has to be probated, it's what we call one bag of drama, pure pasa pasa. And that is because people don't sit and put things in writing. All of the drama. And so when somebody die, you can guarantee that there's going to be drama. And the
Hmm.
sad part of it is sometimes when the persons are alive, the same family members who are fighting never look on them a day in their life. But as soon as they're dead, everybody wants something. And even some children, once you're a child and you don't have a will, that's another drama. They come forward. And so it's an interesting area of law that I find people need to be educated. This is something that is serious. And sometimes the same children who you don't see for years, they end up getting so much out of their estate. And I know sometimes if these persons were alive, they would be, so shocked. So I believe that it's a room for growth, this area of practice, and that every lawyer should be on a mission to educate persons in Jamaica that look, estate planning is very important. You work hard, you rack up and you get all these assets, but you ever stop and think, how should these assets be treated? Or
Hmm.
how should they be treated if you're incapacitated? Because life sometimes can throw curveballs and sometimes we lose our mind. And it's most of the business persons who are doing so much things in their work life that they lose their mind. They have so much bills, so much projects to maneuver. And so that reality is very much real. So it's important to have estate planning as a part of anyone's agenda. It's important to understand the processes. It's important to understand how you can just save everybody the fighting. And some people even lose them life over dead left. Dead left carry the most grievances. And so why not
It's
estate
so
planning?
true. We see it all the time in the papers. We see these stories about, family disputes because of, estates that people left behind or no wills being left behind. And then families end up fighting and quarreling over the assets of that person who passed away. So, at what age would you recommend that people start retirement planning and estate planning?
As soon as you have assets, as soon as you start to have more than one or two assets, you should start the estate planning. If you don't have any assets, then there won't be an estate. But once you start to have whether money is in the bank, that can fall part of your estate. Even if you start to own a little piece of land, or it is that you have, you know, other assets that you would have inherited, you have to account for that. So estate doesn't mean that it's things that you own, but you could have inherited from other persons and they form a part of your estate. So anything that you acquire during your lifetime, whether stocks, monies in the bank, assets, real estate, even your chattels, is important to write down how it is to be treated upon your death or even while you're living.
You know, you might even want to start before you have assets. I heard a story recently of a young man who was, I think, was in the police, either police or military, and he died in the line of duty. He didn't have any assets, but because he died in the line of duty, he was entitled to a settlement, a payment or a payout from the government. And his
Yes,
father ended up claiming half of that payment, even though his father had not been involved in this
his
child's life
life. Yeah.
since he was born, since birth. And the mother was so upset because she raised this boy to manhood. He now became police, doing good for his country, died in the line of duty, and his father came and claimed 50% of that
Okay.
payout.
I definitely agree. So that would be another instance in which you start your estate planning in terms of if anything should go wrong, who would inherit from your estate. And a lot of persons also don't know that if you start your estate planning and you get married, so if you have a will and you get married, that will is no longer valid.
Wait, so that again, if you get married and you have a will,
If you had a will before you got married,
uh-huh,
once you are married, that will is no longer valid.
really?
Yeah.
So you would have to go in and change the will.
Yeah, the marriage revokes the will.
The marriage revokes the will. I did not know that.
So once you get married, anything that you'd have set up prior to your marriage, you need to reassess them and do it over all again. So if you had a will, you get married, you have to do over your will.
You know, I suspect that we're going to have a lot of questions tonight because this is a very interesting topic, and I see a couple of questions in the chat already. Speaking of assets, so let's say I have a motor vehicle or a house, could be a property as well, but there is a lien on the motor vehicle or the house, a mortgage on the house, so it's not fully paid off yet. Is that still considered an
Yes,
asset
it's still,
that I
yes,
should
still
put
an
in the will?
asset. The thing though now currently when you're buying properties and you're taking a mortgage from the bank will require you to have a life insurance called term of life. And it runs for the term of the loan so that in the event you die, the bank has to protect its interest. So the life insurance is assigned to the bank. So once it is that you die whilst having that mortgage, the life insurance will be paid out to the bank and then the property will go to your estate. This is now a condition when you're buying a real estate. If you have a property with NHT, a lot of people should know this. Once it is that you die, let us say you hold the property as joint tenant, the mortgage immediately closes. So
Oh,
once you're dead, the mortgage immediately closes. You don't have to worry about that. And so essentially the whatever lending institution always try to protect their interest in setting up these facilities so that in the event of death, their monies are covered plus interest as well as the other remaining parts of the property will go to your estate. So I'm guaranteed if you have a mortgage, certain things are in place to ensure that is overcome should you die.
all right. Let's get into one of the popular questions, and I see it in the chat as well. So I'll just take the question from the chat. This one comes from Ryan. Is a trust fund or a company a better option than a will to manage an estate?
I would say yes. And it depends because if you have a large, complex estate or asset, trust is definitely the way to go. And why I say that, you can do the trust before the person die. So the trust can be done while they're living or after they're dead. With a will, the will only takes effect when the person dies. right? And sometimes the will doesn't cover every single asset, so you have to have a special catch-all clause in that will. Sometimes the will is not properly drafted and executed, and if it is that the will is not in its proper form, then it becomes invalid, and then the estate will go in intestacy, which is a whole different ball game. Why I say trust is because you will account for all your assets. It prevents you from probating anything because you'd already have created the trust whilst you're alive, and it's simply to manage your affairs. Now, I would always advocate to do your things while you're living. So set up your trust while you're alive so that your assets upon death, there's not a lot of drama. Because if your executors, if you go the will route, do not probate your will, then your asset will just sit there.
So the next question is, can this be done in Jamaica?
Yes, a trust can be done in Jamaica.
So what's the process to start that? How do you go
Right. So,
about
for
it?
example, you can hold property, you can give someone a life interest. How that means is you can transfer the property for the life of this person, and upon death, it will be transferred to A. So, for example, I have a property, I want to gift it to my son. I would say, okay, I will hold it for the life, hold it for my lifetime, and upon my death, it is to be given to the son. Upon the death, the death certificate will be used. A lawyer will take over and using the life interest created and transfer the property solely to the son. So nothing has to be probated. No process through the courts has to be done. It's just a simple transfer based on the life interest created. So you can also have a trustee, and the trustee will act on behalf of that beneficiary if it involves a minor. So it depends on the asset. You can create a life interest to give someone to hold on behalf of until that person attains a certain particular age, or you can just do a straight transfer. So let us say I have a son, I don't want to wait until I die, I don't want to wait until he's 18. I can just do a transfer whilst I'm alive and transfer to the son, inter vivos, mean whilst I'm living. And that's it. So if I'm dead, that doesn't affect anything because the title would have already bore the son's name.
You know, when
So
you hear trust, and trust fund, that sound like rich people thing. Is
it's
this
really
something?
not. It's
Is
just
this
some
something?
fancy terms.
Is this something that the average Jamaican can do?
Yes, it is. So what I would suggest that you get an attorney, you do you list out all the assets that you have, what you want to do with it in the event that you're incapacitated or upon the death, and the lawyer will guide you to say, okay, you can transfer it now, because let me tell you, once that person dies, there's something in Jamaica called debt duties. 1.5% of whatever the property values at the time of death is what you'll have to pay. The government exempts you up to $10 million. After $10 million, you have to pay 1.5 of the value of the property as a tax to the government. So in terms of cost, it is important that you just do what you're doing whilst the person is alive to save you all that financial burden.
Fire Economics wants to know, does it make sense to have a trust if you don't have a large estate?
If you don't have a large estate or a complex estate, let us say you just have one piece of land somewhere down in the country, and you don't have any money to create a trust, you can simply do a will. So the will is cheaper in the short term, but it's expensive in the long run. The trust is expensive in the short term, but inexpensive in the long run. That's the best way to explain it.
All right. Next question comes from Life Roots. If my assets are in a trust before marriage, does the marriage revoke it?
No, that's the distinction with the will. If you have created the trust before the marriage, it doesn't revoke the trust because the trust is basically final. It
Okay.
gives that protection.
That's a good distinction indeed. Fire Economics wants to know, how do you choose a trustee, especially with the steep regulatory requirements? And does it make sense to have a trust in Jamaica? Well, you already answered this part, without a large estate.
How
But
do
how
you
do
choose
you
a the trustee? Same way in which you choose an executor. You look amongst your relatives or friends. Who amongst them I feel like upon my death, or even if I'm alive, will pull up their end of the bargain. Is this person honest? Is this person trustworthy? Do I feel if I make them a trustee, they will act within the best interest of the beneficiary? It's really a character based question. If you know the person is not of a good character and is not someone who will live up or is responsible and or reliable, then don't make that person a trustee. So it's really a matter for you to look amongst yourself and determine whether or not. If you can't find somebody, you can always ask if you have a family lawyer for the lawyer to act as a trustee, and they can advise you, because they can in certain regards act as a trustee, based on the nature of your relationship with an attorney.
James wants to know, what if you have, I told you the questions would come. What if you have two executors that have been neglected for 15 years to probate the will for the estate?
All right, so the two executors, there's a term called renunciation of executor. If it is that, for example, I'll give you a scenario. If one of them don't decide to do what they need to do as executor, they can renounce their responsibility, and the remaining executor will proceed to probate the will. If both of them have no interest in administrating the estate, then the beneficiary will have to apply to the court to take on the role as if they were an executor based on the circumstance. And the court won't just grant it. You have to show a scant disregard by the executor, and you'd have to show that over reasonable timing, he or she, as the executor, have not performed their duties within the best interest of the estate, and as such, either the assets are at stake or the assets are in limbo. And if it is that you do not act now, then the beneficiaries stand to be at a great disadvantage. So you have to, the threshold is very high, and you'd have to show the court that me as the beneficiary taking on the mantle as an executor is in the best interest of the overall estate.
Question coming from Kirk. What about a holding company?
You can always use a holding company to hold assets on trust. But bear in mind that your holding company will have its regular obligation as a holding company.
What does that mean? What are those
So,
obligations?
as normal companies have obligation for annual returns and compliance with the company's office on a yearly basis, all of that. So, having a holding company is not necessarily to be used as a shield, but it can be held in the company as a means, as a trustee, as an individual, because a company is a separate legal entity and can be treated in isolation. So you can use your company to act as a trustee.
Ah, okay. What are some of the most common mistakes that you see when people are preparing their wills or trusts?
One of the most common ones is that they put a joint tenancy property in the will. A property that is held as joint tenants cannot be placed in a will. Similarly, if you have a bank account with two individuals, the person who is creating the will and someone else, you cannot name that, because a property held as joint tenancy, there is a rule of survivorship. Once it is that the person is deceased, the remaining person, the surviving holder, becomes the owner completely and to the exclusion of the deceased person's wishes. For
Mm,
example, I have a property, I own it with my husband as joint tenant. We have a child. I put in my will, I give my share to my child. Once I'm dead, it has no effect because it is a joint tenant. The property goes directly to the husband, even though I would have itemized that I want my share to be given to my son. So we
okay.
have to understand that putting everything in a will doesn't mean it have any efficacy. If it is not done, if it's a tenancy in common, then it's a different story. But once it is held as joint tenants, you can't put it in the will because it has no
That
effect.
sound like the basis for argument. So the son is gonna come and say, "My father left this to me in his will," and then the wife take it and she don't want to give it to me.
And I can tell us that this has been the subject of many court cases because you have to keep on telling persons not everything must be itemized in a title because it has no legal effect. If you have a bank account and you hold it with your sister, let us say you alone put in the money on it, it was your account, and you just add your sister name on it. When you're dead, everything goes to the sister, every money goes to the sister because you cannot will funds held in that account. If your sister is named on it, your sister has the right to go to the bank, present your death certificate, and take the money and gone. And you can do nothing about it. It would just be if it's on a conscience that you say, well, my sister always put money in it. I never put any dollar. I was just placed on it for placing sake. I am going to give it to who she said should get it. Then that's a different story. But if she chose to go to the bank, present the death certificate, and take the money, nobody can do anything.
I assume the thinking would be that, well, I'm entitled to 50% of that assets, that bank account, that property. And so my 50% can go to who I choose.
Nope. And that's a common mistake that people don't know. And that is why I said when you're doing your will, seek legal advice. Don't, I know another thing I see Jamaicans doing, them buy a will form, they go to a JP, they sit down, the JP write up them form, write up them will, the JP witness it and everything. And because the JP is not seized of certain legal understanding, they put gifts in there that really and truly, when I reach the point of probating the will, the gifts cannot be distributed based on the wishes of the deceased because it cannot be done in a manner in which it was itemized. So a lot of people need to understand that it's not just buy a will form and write up a will. Certain gifts cannot be given
Like what?
based on how. Just as how I said, if you held it in a joint account, and if, for example, let us say people do this all the time, they will say the land located at Farm Road, St. James, to my uncle. If you don't specify and you have more than one farmland in St. James, it creates a problem. This gift must be specific in terms of itemizing the location, volume and folio number, properly describe the gift. Because if it is something that is unclear, then you can create problems. And maybe really and truly, the gift may not be able to be distributed because it is not specific. It's too vague. I've
Okay.
seen wills where they said 2 chains land, Saint Anne, to my brother. Where is the 2 chains land? Or you find 2 chains land.
But then wouldn't you have title for the property? So
Yeah,
then
but some old people, they will say 2 chains are 2 acres, and them have ways of describing the land. Only them alone know what they're describing. So you have to properly describe the gift in the will.
Okay. Sarah wants to know, what are the items that can be willed to children if the parents are joint tenants?
You can't will nothing at all. If they're joint tenants on the title, you can't will it. You'd have to sever the tenancy and do a tenants in common if you want to will your share.
Okay. New Methods has a question. Can my trust be domiciled in another country, let's say St. Lucia, for tax purposes with my portfolio?
Yeah, you can have another trust in another country, but bear in mind, and similarly with wills, if you have a will, let us say in England, and you have assets naming that will that you want to distribute, that will has to be resealed in Jamaica. It's called a
Oh,
resealing of the will. Similarly, if you have a trust in another jurisdiction, your trustee would have to seek to administer it if the assets that are named in that trust is located in Jamaica.
okay.
So just don't avoid the tax, just get it done for this country because it's still gonna cost them.
Speaking of tax implications, are there any specific laws or tax implications in Jamaica that people should be aware of, especially when
Yes,
passing on property or savings to their children?
when you have the will, you have to probate it as fast as as possible.
What does
Every
that mean?
year.
What does that
So
mean?
so if
You
the
have
person dead today, you have to ensure that you probate the will within the year.
what does
Because
probate mean?
meaning that so probate mean the executor will sign the documents, file it in court to have the will. So the will in itself has no effect. It has to be probated, mean it goes through the court to get its legitimacy.
Okay.
Once it's legitimized, then you have to pay what is called death duties. Once you die, you have to pay what is called transfer tax to the government before any beneficiaries can be placed on that title. Now, the government charge 1.5% of the value of the property as at the time of death. And every year from that person die until you probate that will and have that transfer assessed, you have to pay penalty. So you have the 1.5, and this is any asset above 10 million. Because once it's 10 million, then you don't pay any tax. Once it goes above the 10 million threshold, you have to pay $10 million on you have to pay the 1.5 on the excess.
So if you have a house, and quite likely the house is more than 10 million, you have to find 1.5% of the value of that house to pay to the government to transfer it.
Yes, yes. So let us say
What happens if you don't have it? If you don't have that cash?
you have to pay it. That is why I always advise persons go the trust way because you would have been put the name on the title already. So when you're dead, there's nothing to be done. But when you have a will and to probate a will, the legal fees alone is between 3 to 5%, depending on the attorney, 3 to 5% of the value of the total estate of the individual. Say the person have a land, a car, every estate, the lawyer will tally that, and you'd have to pay in legal fees 3 and upwards to 5% of that. That's the standard market rate that attorneys are charging. That is just to probate the will.
Plus the 1.5% to the
Plus,
government.
that's why I said, looking at a normal estate matter will run you run about a 2 million bill. If you have a sizable estate, you upwards to 5 million.
And
That is why
if you don't have that money to clear that, you just can't get the property.
that kind of property. That is why it's good to do it whilst you're alive.
But then who gets the property? What happens to the
It
property?
sits there until you can afford.
It just sits there
Yeah,
indefinitely.
you cannot transfer the property to the beneficiaries unless they pay that tax. Just
Uh,
as though it is mandated to pay property tax, it's mandated to pay the debt duties, aka transfer tax. And
okay.
that is why estate aspects in the law world is a very lucrative business.
And so when you do a trust, you avoid all of that. You don't have to
Yeah,
pay any of those
you
fees.
avoid all of that. You deal with it while you're alive and you get that over. So it's costly while you're alive, but it's less costly. But the beauty about it, because the essence of somebody knowing that I am gonna be getting this property, can I tell you they find the money? They will find the money. If it's even to borrow it, they will find the money.
Yeah, I mean, to borrow $2 million to get a 50
No
million
man, two
property.
million dollars is the least of their problems. They're getting a new property. And
Exactly.
can you imagine if it is that their father left something, a mansion, they're gonna find the money.
Hmm.
They're going to find it. So you're sitting there and you're saying, oh my, where they're going to get the money from? They find it. And if they can't find it, what they do is to tell the lawyer, say, look, sell the asset and take out all of the fees.
Mm-hmm.
And just give me the excess. That is what happens most of the times.
Right, right, right. All right. So, oh, I feel like there's so many other questions. This is a topic that we can talk about for an extended.
Forever. Hence why I love it.
Yeah, there's so many things to talk about. So, what role? So here's another one: power of attorney. What role does power of attorney play in retirement and estate planning?
You know, I'm glad you said this, ask for this question because it's like every client I tell them. You see, once, so you use the power of attorney to give someone else, the power to whether to go to the bank, to do transaction, to sign documents, any power that you want to give them. But this is what people don't know. Once they dead, the power of attorney dead. The power of attorney has no life once you are dead. So you can put in your power of attorney to say, my friend Janelle, please give my brother this money when I am dead. Can't do that. Because upon you dying, the power of attorney is dead. It only
Oh,
speaks to giving power whilst the person is alive. And I normally say a good way how to use it is, let us say you're migrate and you go foreign. And you have your family out here, you have your little bank account, and you have your little properties. Instead of you taking plane every time you want to put out your tenant, or every time you want to go to Scotia to ask them about your money, you give your power of attorney to a family member to do the run up and down for you. So
mm-hmm.
it is perfect for those things. If you can't physically go and do the run up and down and make inquiries, you give power to someone else. Same thing if you're getting too old and you can't bother to do certain things, you can give somebody a power of attorney to act on your behalf. But two things people don't know. You cannot give a power of attorney if you have dementia or if you have mental health problems,
Mm.
because the power must be given whilst you're in your current state of mind. And number two, once you are dead, everything that you would have authorized in your power of attorney is dead with you.
So what they would want is power of attorney while alive, and then trustee or executor after death.
Right.
So
Because the
that
power of attorney have no effect when you're dead. And it depends on what is your need. Let us say you're a businesswoman and you can't bother for your vehicle documents that are expired. You can't bother for a tax office because stand up in the landline. You can give somebody the power of attorney to do these things. They can give them to go to the bank, interface with government agency, and that is it. But you cannot direct someone in your power of attorney to do something when you're dead, because the power of attorney is dead when you're dead. Simple.
I'm going to take one last question from the audience. It comes from Shells. If you have assets in multiple countries, isn't it best to have separate trusts in each country that applies to the asset in just that country?
Yes, yes. If you have assets in different countries, set up trust in the various countries, because some assets may be governed by that jurisdiction's law. So
Mm.
if you cannot direct what is to happen in a Canada or another country, especially if that country is not a part of the Commonwealth, which we subscribe to. So I would advise, if you have multiple assets in multiple countries, have your trustees in various countries, that the trust is based on the applicable laws that govern that country, as well as things are in that prescribed format, because you can't have any applicability because of cross jurisdiction policies and procedures.
Well, Michelle, we're getting a lot of interest in this topic. Before we go, Ryan wants to know, he says, I need your contact number. You really know what you're talking about. She sold me on her knowledge. So
No,
just
thank you.
tell people how they
Simple
can.
number 451 1111. It's a simple number 451 1111. Can call me anytime.
All right. Thanks so much for joining us, Michelle.
Thank you for having me.